What is up, folks? This is Zaddy Ads, and lots of updates going on as far as the Ghislaine Maxwell docket. Scotty David, juror number 50, has been subpoenaed for a hearing at 10 a.m. on March the 8th, 2021. And I'm going to be there. It's actually coming up here in a few days, just under 2 weeks. And I want to go over some of actually pretty much all of the docket entries from yesterday, and there was actually one today as well. In addition to his questionnaire, Scotty David's questionnaire, we got, so we're going to go over that as well and kind of see what's going on here. So this is Honorable Allison J. Nathan, United States versus Ghislaine Maxwell, 20 CR 330. This is from the government, Damian Williams, saying, "Dear Judge Nathan, the government respectfully submits this letter in response to the court's February 24th, 2022 order, which directed the parties to inform the court whether either seeks limited redactions to the court's February 24th opinion, an order filed under temporary seal. The government does not seek any redactions to the court's opinion and order filed under temporary seal. Respectfully submitted, Damian Williams." So government not really changing their line of thought as far as the redactions or lack of redactions that they want on this mistrial motion. So this is the motion officially on behalf of Ghislaine Maxwell for a new trial. Pagliuca, Menninger, Everdale, and Sternheim all signing, with Pagliuca and Menninger being from the same law firm, and then Sternheim and Everdale from each of their own as well. And it goes over their whole motion. I won't go over all the cases they cite, but introduction and conclusion, I think it's safe to say we can cover. Juror number 50 says he was a victim of sexual assault and sexual abuse as a child. When he told his fellow jurors of this abuse during deliberations, the room went dead silent. Juror number 50 has told several media outlets that he drew on his personal experience as a victim to persuade fellow jurors to believe Ms. Maxwell's accusers, despite the inconsistencies and holes in their stories. Even though they delayed disclosing their allegations against Ms. Maxwell, in despite of expert testimony from Dr. Elizabeth Loftus casting significant doubt on the reliability of their claimed memories. This was fair and prejudicial to Ms. Maxwell, and it all would have been avoided if juror number 50 had told the truth during voir dire, but he didn't. To the contrary, juror number 50 repeatedly and unequivocally denied having been the victim of sexual abuse, and he denied having any experience that would affect his ability to serve fairly and impartially as a juror. Had juror number 50 told the truth, he would have been challenged and excluded for cause. The Sixth Amendment to the United States Constitution guarantees trial by jury. Fundamental to that guarantee is the promise that the jury will be comprised of 12 dispassionate individuals who will fairly and impartially decide based on the evidence or lack of evidence, and not on their personal predilections and biases, whether the government has proved its case beyond a reasonable doubt. Voir dire plays an essential role in this process, and it depends on potential jurors to truthfully answer material questions put to them by the court and the parties. This did not happen here. Juror number 50 did not truthfully respond to perhaps the most important question, but to potential jurors about their personal experiences, a question that pertained directly to the core allegations against Ms. Maxwell, whether they had been a victim of sexual assault or abuse. Juror number 50's false answer undermined voir dire, resulted in a jury that was not fair and impartial, and deprived Ms. Maxwell of her constitutional right to a trial by jury. The court should vacate the judgment and order a new trial. And then they provide factual background, and this entire motion is 66 pages, and there are redactions, as you can see, which kind of shows a slight win for the defense because they wanted everything redacted. But let's go to the conclusion here. The purpose of voir dire is to expose bias or prejudice on part of the venirman, and there must be sufficient information elicited on voir dire to permit a defendant to intelligently exercise not only his challenges for cause, but also his preemptory challenges. Voir dire thus plays an essential role in protecting the right to trial by an impartial jury. For its part, this court expressed confidence that its voir dire process would smoke out a juror who was dishonest. Ms. Maxwell relied on the court's process, and the court and the parties relied on the presumption to which everyone is entitled, that potential jurors would carefully and honestly engage in voir dire. Unfortunately, we now know that juror number 50 and at least one other juror did not honor their obligations to give only truthful answers, truthful underlined. They are no longer entitled to the presumption of honesty. Because Ms. Maxwell's jury was not the fair and impartial one guaranteed her by the United States Constitution, this court should vacate the jury's verdict and order a new trial. In the alternative, the court shall hold an evidentiary hearing and examine all 12 jurors. Respectfully signed, attorneys for Ghislaine Maxwell. And that is the motion that was released recently that the defense wanted entirely redacted, but it only got partially. And okay, so I guess it's voir dire. I was mispronouncing it, but it's the formal voir dire, the formal examination of a prospective juror under oath to determine suitability for jury service, or of a prospective witness under oath to determine competence to give testimony. So in case anybody was unaware of what that exactly meant, and looks like the rock fin is not functioning for some reason, but that is quite all right. And let's continue here. And they did have some exhibits as well, which I'm going to go over. And one of them, as I mentioned, was the questionnaire. So we're going to see that right now. Probably going to be redactions, but let's see. So this is juror ID number 50. This is the questionnaire that they went over. And we're going to see how Scotty David answered. So let's see what the questions are. It says, please note, in the event you are excused from service on this jury, you will likely not be excused from jury service in general. You will instead be required to report to the court's jury clerk for placement on another panel for another case. So let's see what's going on with this. Question 1, do you have any unmovable commitments between the 16th of November and November 19th? No, he says. Do you have any unmovable commitments between November 29th and approximately January 15th? So this is interesting. As we mentioned before, they expected this trial to go mid-January. So 6 weeks in total. It went only a month in total. Do you have any international travel plans? Do any circumstances exist that such serving on the jury in this case would entail serious hardship or extreme inconvenience? Do you have any personal commitments that would make it difficult for you to get to court? Do you have difficulty understanding English? Do you have any mental or health conditions, medication that could prevent you from giving full attention at the trial, religious, philosophical, or other beliefs that would make one unable to render a verdict in a criminal case? And it says, do you accept the principles of law that the criminal case or that the defendant is presumed innocent? Do you accept the principle of law that the facts are for the jury to determine and the law is for the judge to determine? So pretty standard stuff, it seems here. Do you accept the principle that the law provides a defendant in a criminal case an absolute right not to testify, and that the juror cannot hold it against the defendant if she chooses not to, which, as we now know, she chose not to. That was the only time we heard her speak, and I believe I was the first one to get the quote out, but I could be wrong. A juror is required by law to make his or her decision based solely on the evidence or lack of evidence presented in court, not on conjecture, suspicion, bias, sympathy, or prejudice. Do you accept this principle? They also ask about the issue of punishment must not enter into deliberations as well. And you can hear testimony in this case that law enforcement officers recovered certain evidence from searches. Do you have any opinions about searches conducted by law enforcement or the use of evidence obtained from searches that would affect your ability to be fair and impartial in this case? Have you had any experiences with experts? So, basically just testing to see their impartiality. And this one's an important one. It says, from now on, till your jury service is complete, you're instructed to avoid all media coverage and not go on the internet with regard to this case. You're prevented from consuming any news on it. And you also must not discuss this case with anyone, including family, friends, spouse, etc. Prior jury service they ask about experience as a witness, a defendant, or as a victim of crime. Is there anything? But I'm not seeing any questions about being a victim of abuse or assault. Relationship with and view of government defense. Do you have any family members or close friends that work in law enforcement? Would that affect your ability to be impartial? Do you have any associations with anybody in the SDNY, in the FBI, in the NYPD? Do you have an opinion of Damian Williams? And then they ask if any of their family or friends personally know Epstein, personally know Maxwell, personally know people who work for the SDNY, personally know any of the government lawyers, any of the defense lawyers, if they know Judge Nathan. Before today, had you read, seen, or heard anything about Ms. Maxwell? Yes. And then you have to put the source, and it looks like he says, I read on a website that she was Jeff Epstein's girlfriend. The source was CNN. Have you personally formed an opinion about Ms. Maxwell's guilt or innocence based on what you heard or saw? He says no. Based on what you heard, saw, or read, have you formed any opinion about Ms. Maxwell that might make it difficult for you to be impartial? Have you read, seen, or heard anything about Jeffrey Epstein? Yes. CNN was the source. Heard about his death and that he was in jail awaiting trial. Have you verbally stated or posted your opinion about Maxwell or Epstein? He said no. Based on anything you have read, seen, or heard about Jeff Epstein, have you formed opinions about Epstein that might make it difficult to be impartial? He says no. If you have heard about Jeffrey Epstein, do you think Ms. Maxwell's alleged association with Jeffrey Epstein will make it difficult for you to fairly and impartially consider the evidence? No, he responds. Would you be able to follow the court's instruction and put any information you have read, seen, or heard about Ms. Maxwell out of your mind and decide this case based only on evidence? He said, yes. During this trial, you will hear evidence alleging sex crimes against underage girls. Some of the evidence in this case will involve sexually suggestive or explicit conduct. Is there anything about the nature of this case and the accusations as summarized at the beginning of this questionnaire that might make it difficult for you to be fair and impartial juror in this case? He responds, no. Do you have any specific views or feelings concerning laws regarding the age at which individuals can or cannot consent to sexual activity with other individuals that would affect your ability to serve as a fair and impartial juror? He says no. Do you have any opinion about the enforcement of federal sex trafficking laws or federal laws concerning sex crimes against minors that would prevent you from being fair and impartial? He says no. Have you or a family member ever supported, lobbied, petitioned, protested, or worked in any other manner for or against laws, regulations, or organizations relating to sex trafficking, sex crimes against minors, sex abuse, or sexual harassment? He says no. The witnesses in this case may include law enforcement. Would you have any difficulty assessing the credibility of a law enforcement officer, just like you would any other witness? He says no. It's kind of a weird question. Witnesses in this case may testify claiming abuse, sexual abuse, or sexual assault. Would you have any difficulty assessing the credibility of a witness claiming sexual assault or abuse? He says no. Have you or a friend or family member ever been the victim of sexual harassment, sexual abuse, or sexual assault? This includes actual or attempted sexual assault or other unwanted sexual advance, including by a stranger, acquaintance, supervisor, teacher, or family member. He said no. There it is, folks. There it is. That's the question. That is the question right there. That's the question. Double entendre, wordplay. They asked him straight out, explicitly, have you or a friend or family member ever been the victim of sexual harassment, abuse, or assault? And Scotty David, juror number 50, replied no on his juror questionnaire during voir dire. And is that enough for a new trial? That's the question. And then they asked the same thing. Have you or a friend or family member ever been accused of sexual harassment, assault, or abuse? He said no. Is there any other experience that you or anyone close to you has had that may affect your ability to serve fairly and impartially as a juror in this case? He says no. Do you wish for your answers to remain confidential? He says no. I, juror number 50, declare under penalty of perjury that the foregoing answers set forth in the jury questionnaire are true and correct to the best of my knowledge and belief. I have not discussed my answers with others or received assistance in completing the questionnaire. Signed this 4th day of November, 2021. Wow, that's big, folks. That is big. Let me just take this off for a second. Follow the white rabbit. Wow. Okay. This is worse than I thought, I think, because they asked him explicitly in question 48, the second to last or third to last question, and he said no. And then he comes out after the trial with permission from the Carlisle Group, his employer, to make statements that he used his past sexual assault experience as a victim to persuade the other jurors. What is going on? That's not good news for people who want to see justice in this case, or to put it more specifically, if you don't want a new trial. Okay, this is a comment. 2 prosecutors from the SDNY resigned from the tax case being used to harass Trump. One of them, Pomerantz, was the surname. Any relation to the other Pomerantz? Probably. Let me see. That's a good question. I actually don't know what's going on there. I thought I saw Mr. SDNY himself covering that case, but I'm not certain about it. Okay, Attorney General, no, what is this? Yeah, it is Letitia James. Investigating whether President Trump's family business misrepresented its asset value and allowed certain executives to scuttle taxes by compensating them with off-the-books perks. Let me see if I can find this. If I can find the docket, I should be able to answer that question pretty easily. But SCOTUS clears pending Trump cases off the docket. There's a Wikipedia page, list of lawsuits involving Donald Trump. That's kind of funny. But none as far as Trump as defendant. And, of course, there's the Paul Manafort one. Yeah, I'm going to have to get back on that. But let's see what else is going on here. Blessing Addy, good morning. Did I miss many minutes? Okay, let's continue here, people. So I'm going to, wow, that's big. That's big, folks. And let's go over, this is not that long, but this is the, yeah, this is really short. This is when the juror first was spoken to by the court, I believe, during this process. And this is, I think, the next exhibit here, with appearances by Maureen Comey, Allison Moe, Laura Pomerantz, Andrew Rohrback, Damian Williams, and for the defense, Pagliuca, Everdell manager Sternheim. Renato Stabile, I've never seen that one before. Also present Sonny Drescher and Camille Delgado, paralegals. Okay, juror number 50 enters the room. Good afternoon, juror number 50. I'm Judge Nathan. It's nice to see you in person, and thank you for your time. I'm going to ask you some follow-up questions related to some of your responses that you provided and some additional questions. First, as I instructed you earlier, the defendant in this case, Ms. Maxwell, is presumed innocent of all charges unless and until the government proves her guilt beyond a reasonable doubt. Are you able to follow that instruction? Yes. As I instructed you, until you are excused from the case, you may not take in any kind of media about the case, social media, TV, radio, online, print, anything, or discuss the case with anyone. Would you have any difficulty following that instruction? No. Since you took the questionnaire, now is the time to tell me. Have you read or researched or discussed the case with anyone? I have not. Schedule. The trial will start on November 29th. We estimate approximately 6 weeks. Can you sit during that time? Yes. I'm going to ask you to pick up the binder in front of you, please. If you turn to tab 2, there are 3 pages that list names of people who may be mentioned during the trial. I want you to take your time, read all of those names. If there are any that are familiar to you, please let me know what number. Juror says none. The court, three pages, none. Then the next tab is 1 page, and it lists some address and entities that may be mentioned during trial. Have you heard of any of them? Or here the question is not whether you had heard of any of them, but do you have any specific familiarity? He says no. And Judge Nathan says, then the last tab, as the instructions say, don't say it out loud, but just say yes or no. Other than having heard of it, do you have any specific familiarity? No, I do not. And we can't see what that is referring to. You can put that aside, said Judge Nathan. You have indicated in your questionnaire that before the questionnaire you had heard about Ms. Maxwell. Do you recall where? I heard when Jeffrey Epstein had died that he had a girlfriend just from a news article, a news broadcast on CNN. Other than what you just described, do you remember hearing anything else about Ms. Maxwell? Nothing. The question is, it's an important question. Can you put aside anything that you have read or heard about Ms. Maxwell and decide the case based on the facts and evidence or lack of evidence here presented in court? Absolutely. And follow my instructions as to the law? Yes. In your questionnaire, you indicated before the questionnaire you had heard about Mr. Epstein. What you described, you said CNN. Other than what you have described, do you recall anything that you heard about Mr. Epstein? Not really. I don't really have cable, so it's very rare that I even see anything. Based on what you did hear or read, the stenographer spelled here wrong. Based on what you did hear or read previously, same question. Can you put it aside? Decide the case based on the facts and evidence or lack of evidence here presented in court. Yes. Any doubt about that? No doubt. Let me ask you, do you have any reason to think you might have any bias, either for or against law enforcement of any kind? No. Any reason to think you have any bias for or against criminal defense lawyers? No. Do you have any opinion about the criminal justice system generally, or the federal criminal justice system that might make it difficult for you to be fair and impartial here? No. Do you have any opinion about people who are wealthy or who have luxurious lifestyles that might make it difficult for you to be fair and impartial here? No. Counsel, anything further for background questions? Pomerantz, no. Sternheim, no. Nathan, juror number 50, how old are you? I am 35. What county do you live in? I live in Manhattan. How long have you lived here? 10 years. How far did you go in school? I finished my bachelor's degree. What did you study? Finance. Are you working now? Yes. What kind of work? I'm an executive assistant in finance. And you work at a private company of some kind? Yes. How long have you been in that position? With this company, the Carlyle Group, that is, almost 4 years now. Same position with another company prior to that? Yes, ever since I graduated college in 2008. Do you live with anyone? I live alone. Do you typically read any newspapers or magazines, either in print or online? No, I do not. Do you frequently visit any particular websites? No. Ever comment or post on websites? No. Do you use social media? I do, but I actually just deleted them because I just got out of a relationship and I didn't want to see anything regarding them. So I'm fully off of it right now. What did you use? Facebook, Twitter? I used Facebook and Instagram. When you had those, what kind of stuff would you post? Would you post about news of the day or politics or personal stuff? Personal stuff like selfies. How long ago did you delete your accounts? It was actually last week. Do you watch television? I have Netflix, so I watch Netflix. What kinds of shows? Comedies, funny things. Do you listen to the radio? I do not. I do listen to music, though. What about podcasts? I do not. Hobbies or things you do for fun? I love to travel and hang out with friends. Have you ever followed a criminal case either on the news or podcasts or the like? I have not. Any clubs or organizations to which you contribute time or money? I do not contribute to anything right now. You have in the past, in college. In these questions, I have tried to, of course, get a sense of whether you can be fair to both sides in this case. Any doubt about your ability to do that? No. Other than what I have asked you, do you have any reason to think that you can't be fair and impartial here? I do not. Counsel, any questions? Pomerantz, no thank you. Sternheim, no thank you. The court. Juror number 50, thank you so much. My law clerk is going to give you instructions about the next step, and I thank you for your time. End of Exhibit 2. So that is what I wanted to share for the second exhibit there. Basically just a recap with the court and both sides after the questionnaire. And that is, wow. It was that question 48, man. They did ask it. So pretty interesting stuff there. And there was actually an entry on the docket today as well. So let's just take a peek at that. This is from Sternheim, I believe. She said, Dear Judge Nathan, in response to today's court order, docket 610, the defense proposes limited redactions to the attached opinion in order dated February 24th, filed under temporary seal. So that was what she was referring to, was submitted yesterday. So that's more of like a formality than a new update. But let me just read this here, because this is from yesterday. Order as to Ghislaine Maxwell, for the reasons fully explained in the opinion and order, a hearing is necessary to resolve the defendant's motion. Because of the important interest in the finality of judgments, the standard for obtaining a post-verdict hearing is high. The court concludes, and the government concedes, that the demanding standard for holding a post-verdict evidentiary hearing is met. As to whether Juror 50 failed to respond truthfully during the jury selection process to whether he was a victim of sexual abuse. Following trial, Juror 50 made several direct, unambiguous statements to multiple media outlets about his own experience that do not pertain to jury deliberations and that cast doubt on the accuracy of his responses during jury selection. Juror 50's post-trial statements are, quote, clear, strong, substantial, and incontrovertible evidence that a specific non-speculative impropriety, namely a false statement during jury selection, has occurred. And they cite United States versus Baker. To be clear, the potential impropriety is not that someone with a history of sexual abuse may have served on the jury. Rather, it is the potential failure to respond truthfully to questions during the jury selection process that asked for that material information so that any potential bias could be explored. In contrast, the demanding standard for ordering an evidentiary hearing is not met as to the conduct of any other juror. The court denies the request to conduct a hearing with respect to the other jurors. The court also denies the defendant's request for a broader hearing and pre-hearing discovery. The court therefore orders that a hearing take place at which the court will question Juror 50 under oath. The court further orders that Juror 50's questionnaire be unsealed for the reasons explained in the opinion and order, which we just went over. The court will email counsel for Juror 50 a copy of his questionnaire, a copy of his order as well. Also, as also explained in the opinion and order, the court will conduct the questioning at the public hearing with input from counsel for the defendant and the government. The parties may submit by mail proposed questions in accordance with the opinion and order on or before March the 1st, 2022. The hearing will take place March the 8th, 2022 at 10 a.m. The court orders Juror 50 to appear in courtroom 906 of the Thurgood Marshall United States Courthouse, 40 Center Street, New York, New York, at that date and time to give testimony under oath in response to the court's questions. The court will ensure public access and will provide information on public access as soon as it is available. The court will send the temporarily sealed opinion and order to the parties. By noon on February 25th, 2022, the parties are ordered to inform the court whether either seeks limited redactions to the opinion and order, conforming any request to this court's prior order, docket number 596, and justifying any such request by reference to the three-part test articulated by the Second Circuit, citing, once again, Second Circuit in Lugosh versus Pyramid Company of Onondaga, which they've cited before. So there you have it, folks. Big stuff. Big stuff there. Let's check out the comments. Cyrus Vance initiated the case as political weaponization, but Vance is retired now. What if he had answered yes, defund the popo? Juror number 50, how many others got rejected from jury pool? That's a good question. I would imagine it was probably quite a bit, but I don't know at this point in time, so I can't say. But a very interesting question for sure. So that being said, folks, please buy my book if you can, How to Cover the Ghislaine Maxwell Trial. It's on Amazon for $9.99 paperback or $5.99 ebook. Please support if you can. It would be much appreciated. This will be available anywhere podcasts can be found, as well as Rockfin once I get that fixed. And additionally, follow me on Twitter. Buy me a coffee if you can. Stay frosty. We'll see everybody next time. Ciao.